Morning.
Can you hear me?
There you are. Yeah.
Okay. Yeah. Dar tested positive, so I'm down at the Hilton.
You're at the Hilton?
Yeah.
Is that what you said?
I'm hoping it doesn't look too much like a,
Oh, you really are at the Hilton.
yeah.
Oh,
Mhm.
wow. I was going to say, oh, wow. Were you with her this week or something?
Yeah, we walked on Saturday.
Oh,
So, okay. Let me see if they want a record.
sure. But the second part, they probably will, right? But I could,
So,
yeah, just whatever.
see who else here. Right. Good morning.
Morning, Judge.
Hang on.
Morning, Your Honor.
Good morning. Is Mr. Brockett coming?
Good.
Yes, ma'am. He's over at Mr. Estes's office, but he took a little laptop with him and he said he would be signing in. So
Oh, okay.
let's see. Is
Very
that?
good.
Let me text him and see where he
Oh, no rush. We're okay. This is the only thing I have this morning, so we're okay.
will say that Mr. Brockett is even less technically oriented than I am, which is not very. So
We're all learning through this. There he is. All right, good morning. We have three motions today. One is partial summary judgment, the defendant, and two are motions to exclude testimony of witnesses. Which ones do you all want to take up first?
Your Honor, I would like to start with the motion for summary judgment, then move on to the motion to exclude Dr. Eilers, and then finally the motion to exclude Dr. Ewing.
Okay, Dr. Eilers, we're only going to do part of it, I believe.
That is correct, Your Honor. It's my understanding that plaintiffs intend to bring Dr. Eilers live to testify and on issues relating to his qualifications and some issues relating to reliability. We will deal with those on December 18th. What we're talking about today are some timeliness issues.
Okay, just let me pull this up. All right. All right, you may proceed on the motion for partial summary judgment.
Thank you, Your Honor. Your Honor, if I may begin, we represent the Abuelos defendants here. We filed a motion for partial summary judgment based on essentially all of the other claims that the plaintiffs have asserted that do not arise under the Dram Shop Act. The reason that we filed this motion, Your Honor, is that this case is and always has been about one thing and one thing alone, and that is the alleged overservice of alcohol to Jesus Rio. That's been this case for the 3.5 years that has been on file. As a result of that, Your Honor, what that means is that we are under the Dram Shop Act and only the Dram Shop Act as a matter of law. Your Honor, if you take a look at what the legislature did with the Dram Shop Act, they were explicit. In 1987, the Texas legislature decided that they were going to enact the Dram Shop Act because historically, there were no common law duties that providers such as Abuelos owed to third parties. The Dram Shop Act changed that, but they did so with some limitations intentionally. The legislature, when they enacted the Dram Shop Act, made it clear that the Dram Shop Act was going to be the only mechanism that plaintiffs such as the Tenorios were going to be able to use for anything involving the service of alcohol. And they made this clear not one, but two different provisions. Specifically, the Dram Shop Act of 2.03 Section C states, and I quote, "This chapter provides the exclusive cause of action for providing an alcoholic beverage to a person 18 years of age or older." So that's pretty unambiguous, Your Honor. But the legislature went further because they wanted to make sure that the courts and the parties understood what they meant by this. And so Section 2.03A also states, quote, "The liability of providers under this chapter for the actions of their employees, customers, members, or guests who are or become intoxicated is in lieu of common law or other statutory law warranties and duties of providers of alcoholic beverages." In other words, Your Honor, it's in the statute itself. The legislature abrogated all common law duties on the part of providers such as Abuelos. The only duties that Abuelos has to third parties such as the Tenorios are set forth in the statute. As a matter of law, we cannot have any obligations at common law. We have no common law duties of any way, shape, or form. Those are set forth explicitly in the Dram Shop Act and only the Dram Shop Act. And for the 3 years that this case has been on file, the plaintiffs and their attorneys agreed with this position because that's the only thing that we've been sued on for the entire 3 years of this case since it was originally filed, up until about 2 or 3 months ago. 2 or 3 months ago, the plaintiffs' attorneys filed their 4th amended petition. And now, for the first time, they have asserted new claims that were never previously asserted. And now, for the first time, they're trying to go outside of the Dram Shop Act with respect to my clients. And as a threshold consideration, Your Honor, I need to highlight an issue here with respect to the response that the plaintiffs have filed. Because if you look at the response, the arguments that they have advanced are not in response to the motion that we filed or the claims upon which we have filed for summary judgment. And I'll explain what I mean by that, Your Honor. If you look at the language of the fourth amended petition, we are being sued for, I believe, 4 separate claims outside of the Dram Shop Act. In section 9 of the fourth amended, we are being sued. The heading is defendants Abuelos and Abuelos servers violated the Texas Beverage Code and were negligent. So we're being sued for negligence. Section 10, plaintiff's claim of negligence based on respondeat superior. So we're being sued for negligence under respondeat superior theory. Section 13 is malice and exemplary damages. And in that section, they state we're being sued for malice and gross negligence. So that's 4 things that we are being sued for that are outside of the Dram Shop Act. We move for summary judgment on those 4 claims. Plaintiff's response is silent on every single one of those claims. So I think right off the bat, I think that's really the end of the analysis and the end of the argument, because as a matter of law, we filed a motion for summary judgment that the plaintiffs have not responded to. There is not a word in their entire response about any of those claims. And those are the only claims that are in the fourth amended petition. Now, if I understand what their argument is in their response, what their argument is focused on is negligent undertaking. Well, first of all, Your Honor, if you look at the fourth amended petition, there is some language in one paragraph concerning our failure to follow a policy, but that paragraph is under the section of negligence as respondeat superior. There's no specific claim for negligent undertaking. So right off the bat, I'm not even sure that they've properly pled this, but what I do know is that their response is not responding to the motion that we filed. So, but let's look at this. Let's assume for the moment that they had properly pled negligent undertaking. The bottom line, Your Honor, is it wouldn't matter. And the reason it wouldn't matter is because the Dram Shop means what it says. We cite one of the cases called Parker in our motion in our reply brief. And the Parker case states explicitly the Dram Shop Act is exclusive and it means what it says. The Dram Shop says this is the exclusive cause of action. It does not say this is the exclusive cause of action unless you want to bring a claim for negligent undertaking. The Dram Shop means what it says. And let me be clear about what it is that Mr. Bailey is asking this court to do. Mr. Bailey is asking this court to ignore not only the language of 2 separate provisions of the Dram Shop Act, which are explicit and unambiguous, but he's also asking this court to ignore 30 years of binding authority and to become the first case in Texas history that would allow a claim of negligent undertaking to be raised in conjunction with alcohol service. Again, let me emphasize, this has never been done before. This would be the first time any court anywhere in the state of Texas in 30 years has approved this. And again, just to be clear on this, Your Honor, this is not the first time that plaintiffs have attempted to do an end run around the Dram Shop Act by creative pleading or trying to introduce new facts. Every single one of those attempts, however, have been summarily rejected by the Texas courts. And we cite a number of those cases in our reply brief on pages 4 and 5. Those cases talk about, and again, they talk about it in the context of negligence, negligence per se, negligent training, negligent hiring, negligent supervision, DTPA, premises liability. It doesn't matter. Every single one of those cases has uniformly held, if you have an issue involving the service of alcohol against a provider, you're under the Dram Shop Act and you're only under the Dram Shop Act. You don't get to assert anything else, period, full stop. So if you look at their response, Your Honor, what they are arguing, again, I think is just not only not legally or factually applicable, it's also just not correct. And I don't fully understand exactly what it is that they're arguing, to be quite honest. because I think what they're arguing is, well, we've got this negligent undertaking claim, and that arises separate and apart from our claims under the Dram Shop Act. And that's, I think, even if you look at their own arguments and language, I don't think that is supportable. And again, you don't have to take my word for that, Your Honor, because I'll read you exactly what their argument is on page 6 of their response. Plaintiff states, and I quote, "Plaintiff's negligent undertaking claim does not arise from Abuelos's conduct in overserving a guest alcohol, but Abuelos's policy after a guest becomes intoxicated or arrives at a restaurant intoxicated." Think about that argument, Your Honor. What they are saying is, well, we're not saying that we're suing you because you got him intoxicated. We're suing you because of something that happened after he got intoxicated and he was at your restaurant. That's under the Dram Shop. That is literally in the statute itself. Again, if you look at section 2.03a, which is not cited in plaintiff's response, it states, again, liability of providers under this chapter for the actions of their employees, customers, member, or guests who are or become intoxicated is in lieu of common law or other statutory warranties and duties of providers of alcoholic beverages. What that means, Your Honor, is that this argument that they are raising that, well, because you violated a policy concerning what to do with overserved guests, that's different. The Dram Shop says, no, it's not. That is covered under the Dram Shop Act. We do not owe that duty as a matter of law. The second point that I want to raise, Your Honor, is going through their response, Your Honor. I'm not sure exactly what it is that they are arguing, but I know that it's not negligent undertaking. The reason I know that, Your Honor, is because negligent undertaking is a specific cause of action under Texas law with specific claims, and what they are arguing does not really address those claims. The classic example, one of the key cases involving negligent undertaking, Your Honor, is when someone performs a duty that they do not have a common law duty to do. They do it badly, and then they get sued for it. One of the seminal cases that talk about this is in the conjunction of a railroad. In one of those cases, a railroad put up a warning light in an area that they were not legally obligated to do. But they kept it up there for a long enough time, and people relied upon that warning light. And what the court found in those cases is that if you do that, even though you weren't required to do so, you now have an obligation to make sure that that warning light is in proper operation. That's negligent undertaking. And that's not what the plaintiffs are arguing here. What the plaintiffs are arguing here is that we had a policy, we didn't follow the policy. That is the beginning and the end of their argument. They have not identified what duty we supposedly undertook. They haven't identified what it is that we actually agreed to do, and they haven't, or undertake for that matter, and they haven't argued how it is that we did it wrongly or negligently. So again, I don't know exactly what it is that they're arguing in their response, but it's not negligent undertaking. And again, to follow up on this point, Your Honor, this exact argument has been advanced with respect to policy, the failure to follow policies, on numerous occasions, and every single court in Texas, without exception, that has looked at this issue has rejected those arguments. We cite these cases in our reply brief. Specifically, Your Honor, there are numerous Texas cases that state definitively that the failure to follow a policy without more cannot create a fact issue that supports a claim of negligent undertaking. It just can't do it. That is, again, multiple cases have ruled on this exact issue. But again, if you look at their response, Your Honor, their response is explicit in stating that the only thing that they are suing us for is that we did not follow our policy for getting an Uber or a taxi. There is not even an allegation in the response as to what it is that we undertook to do. As a result of that, Your Honor, every single one of those cases definitively and unambiguously states that that's not a viable fact issue that you can rely upon in the context of a summary judgment for a negligent undertaking. And again, I will emphasize this once again, Your Honor, this is particularly true here in a context of a Dram Shop case, Because again, we do not have, as a matter of law, any common law duties to individuals such as the tenorios. That's in section 2.03a. That has been abrogated by the legislature intentionally. The final point that I will just raise briefly, Your Honor, is that the plaintiffs in their response cite one and only one case for the proposition that they are allowed to bring actions outside of the Dram Shop Act, and that's the Love case. We talk about this case quite a bit in our reply brief, so I won't go over the issues, but suffice to say, I'm a little bit confused as to why the plaintiffs are even citing this case, let alone relying upon it. Love is not applicable in any way, shape, or form here, because Love is a case involving and turns upon the existence of an employer-employee relationship, which is not something that we have here. In particular, the Love case, which plaintiffs rely upon, involved a situation involving an exotic dancer, appropriately enough named Mrs. Love. She worked for a nightclub. She alleged that as part of her job responsibilities, her employer, or independent contractor, I should say, essentially forced her to consume alcohol while she was giving private dances to their customers. She sued on that, and the court stated in that context, okay, well, that's not really Dram Shop, because what you're saying is you've got independent liabilities and independent duties that flow from the employer-employee relationship. That's all Love stands for. That's not what we're talking about here. There is no independent duty that the tenorios can assert within this context, because again, as a matter of law, we do not owe any duties to anyone other than those that are set forth in the Dram Shop Act. The final point, Your Honor, is if you were to think logically about what the plaintiff's counsel is actually arguing here, what it would do is it would not only undercut, but it would completely undermine and vitiate the entirety of the Texas Dram Shop Act. Because think about what they're trying to do here, Your Honor. They're saying, okay, well, you got someone intoxicated in your establishment. Okay, that's Dram Shop. We acknowledge that. And we're not, arguing about that. But in addition to that, you also had a policy that you had to get him a taxi and an Uber. Because you didn't get him a taxi and Uber, you are independently responsible, and therefore we get to sue you for negligent undertaking and get exemplary damages. Now, as a threshold consideration, Your Honor, and again, the plaintiffs are not arguing this point, there is no argument here that they are allowed to seek exemplary damages under the Dram Shop Act. Plaintiffs acknowledge that in their response. The only mechanism by which they are making this argument is, well, we got the negligent undertaking. So what they're saying is, if you as a provider have a policy, really of any kind, that you don't follow through on, that allows you, as a plaintiff's attorney, to bring a negligent undertaking case and get exemplary damages in every case involving every overservice of alcohol involving a provider in the state of Texas. That is their argument. That is exactly what would happen if Mr. Bailey is correct in what he is saying, which is, again, I think one of the pretty good reason why this argument simply cannot be successful in this and why summary judgment is, I believe, appropriate here. Again, following up on this, there are no fact issues. There are no issues that are beyond the Dram Shop. There is nothing to go to the jury on. This is purely an issue of duty, and it is a duty that is set forth by the statute. This is a matter of law. There are no facts that Mr. Bailey can rely upon that will get him out of that. Thank you, Ron.
All right, Mr. Bailey.
Thank you, Your Honor.
Okay.
So I would like to begin with the Texas Supreme Court's discussion regarding this issue, because most of the arguments that Abuelos have just put forth have been addressed directly by the Texas Supreme Court. Not all of them. There's a small part that has not, but most of them have been addressed by this. So I want to start, I think counsel probably misspoke a little bit. I think he said that the Dram Shop Act was the first place where there was liability established for alcohol over service in the state of Texas. That was obviously, as the court's probably aware, El Chico versus Pool. Common law duties for alcohol over service were established first. Then the Dram Shop Act was established, abrogating some of those common law duties. So I think that's important just to understand how we to where we are. So the Love case is the case the court, in my opinion, needs to analyze to decide how it should rule on this case. So it is the Supreme Court's pronouncement that's as closely related as we have to our facts. It's not exact, but it's as closely as related that anybody cited in any of the briefs. And so what happened in the Love case, part of it, counsel for Abuelos discussed, was you had a lady who was a waitress at a place called Treasures in Houston. It was a gentleman's club, and she was a waitress in the daytime at Treasures. At a certain time on this particular evening, she shifted from being a waitress to now being an exotic dancer. All right. Why does that matter, this shift? Well, here's why it matters. One was an employer-employee relationship as a waitress. Once she became an exotic dancer, she became an independent contractor. That evening when this occurred, she was no longer an employee, or certainly not functioning in her employee role. She was an independent contractor at Treasures. Okay. So what happens is, and I think the amount of alcohol was very similar. It was about 12 drinks that Treasures served her as an independent contractor that night. And I say that's interesting because in our case, the undisputed evidence is Abuelo served Mr. Rios between 12 and 13 drinks while he was there. So they serve this to this young lady. She leaves and is in a wreck, hurting herself, no one else. So her attorneys file an action against Treasures under the Dram Shop Act for alcohol over service, and then also bring additional negligence cause of actions stemming from negligent undertaking. Now, so what happened procedurally is, as the court's probably aware, many alcohol providers, Texas is one of the only states, I believe the only state, that has a safe harbor provision that says, okay, if you have all your employees certified, make sure that they're certified, and then you don't directly or indirectly encourage the sale of to obviously intoxicated people or minors, then you can be immune under Texas law. There's some more that goes to that, but that's essentially it. Well, Abuelos obviously doesn't meet that here. I think that night there was maybe 32 people there, and one of them was TABC certified, certainly not our server. So that's not at play here, but why it matters is in the Love case, Treasures did evidently have all their people TABC certified. And they also didn't directly or indirectly encourage people to break the law. And so the trial court said, well, we're going to grant summary judgment in favor of Treasures because under the Dram Shop Act, they met the elements of the safe harbor and they win. Okay. Then what happened is the Treasurer said, okay, we met the safe harbor under the Dram Shop Act. The judge said yes. And they said, okay, then that's King's X. We're over with then. And the reason why is they made the same argument that you just heard, where they said, and I quote out of the opinion, Treasures first argues that the Dram Shop Act's exclusivity clause bars all common law causes of action against commercial sellers of alcohol for any conduct that in some way involves providing alcohol. Okay, that's the argument that this court just heard, right? And that's what the trial court heard in Love. And the trial court said, you know what? I think you're right. And so not only did they grant summary judgment on the safe harbor provision, so the dram shop case went away, but they said, I'm buying what you're selling, Treasures, on this is the exclusive provision, and you were a provider of alcohol. I mean, Treasures provided 12 drinks to this lady that was an independent contractor and left. And so they said, that's it, we're over. So the trial court grants summary judgment on both claims, okay? The case goes to the Court of Appeals. The plaintiff didn't appeal the safe harbor provision where the court found on that one. Again, in the elements, they would have been certified, but also didn't directly or indirectly encourage. So that's interesting. So that wasn't taken up. The issue that was taken up was this very argument that Abuelos just made that, hey, the Dram Shop Act is it, and there's nothing else, and there's no other claims that could possibly exist. That's exactly what they argued. And the Court of Appeals said, I'm not buying what you're selling. That's not what it says. And so what the Court of Appeals says, they reversed it. And they said, no, there can be independent causes of action, even though you're a provider. Treasures was a provider, no question. They were the ones providing the alcohol to her. They said, we need to see, is there something else? Is there an independent duty that you violated or that you undertook and you violated? And the Court of Appeals said, yes, there was. Okay, there was. And we'll get to where they found that duty, primarily in the policy and procedure manual. So undeterred, Treasurer says, trial court got it right and Court of Appeals is wrong. And they took it to the Texas Supreme Court in 2002. The Texas Supreme Court said, no, just because they're a provider, if there is something that they undertake to do a duty and it's outside of the actual provision of alcohol, of course they can be sued for that. And so the trial court's decision was reversed. The summary judgment granting, what they're asking you to do here, was reversed by the Court of Appeals, and that reversal was affirmed by the Texas Supreme Court. And they said, no, she can bring her claim, even though she was not an employee. She was an independent contractor. And then they said, and then at that point, Treasurer said, yeah, well, we didn't exercise enough control over her. We didn't know that she was drunk. She just left. We didn't exercise enough control. And here's where the Texas Supreme Court went. They went to the waitress manual, because remember, she was both an employee in the daytime, but then at nighttime, she became an independent contractor. And that's what they went through. And it said Love, who also worked as a waitress, but then was a dancer at night. There was a salesmanship manual, right? And it said, ask the customer if he'd like you to get a dancer for his table. Customers will buy drinks for dancers and buy dances from them, resulting in a larger tab. Okay, so the manual was what they looked at to say, okay, are we going to hold Treasures liable for their actions with regard to this independent contractor? And their undertaking in that case was to put in their manual, hey, basically, you independent contractor, try to get these guys to drink more, right? That's what the basis was. So if we look at our case, and I am going to share the, well, I don't think I can share the screen.
Oh, hold on. Let me get you there. Okay.
Okay. So. Okay. Now, Your Honor, do I have this up on the screen?
You do. Oh,
Okay.
now I have an email.
Oh, I'm sorry. I put the wrong.
There we go.
Another back. Okay. All right. So this comes from the Abuelos manual, similar to the way the Supreme Court analyzed Treasurer's manual. And I've highlighted the section. I'll let the court read it. Okay. So what we're saying is, look, your manual makes it clear. It says, however, even though your restaurant did not serve the guest any alcohol, even if you're not acting as a provider at all, here's the duty you're going to undertake to do. And it goes on further on the next page, which I will rotate. I'll rotate, and it talks about how they do it. They have steps for the way that they do it. You're supposed to try to get them an Uber. If that doesn't, or a designated driver, then an Uber. And worst case, if they just say, no, I'm not doing it, then what do? You call the police on them and have them arrested or have them pulled over. That's what you do. And I'm not going to go through all the excerpts, but they're under Exhibit D and C. We deposed of I'll go ahead and pull that down. Stop sharing. If I can try to do that. I don't know why it's not letting me stop share. Let me see. Well, Your Honor, I don't know why I'm not able to stop share that.
I can do something for you.
I'm sorry.
Not sure.
Well, if I'm,
Can you X out of it?
well, I can, but then I think then it'll pop up on my other stuff. Oh, here we go. There we go. I'm sorry, Your Honor.
Okay.
Okay. So that's what happened. And why is all this important? The reason this is important is because there are two different courts of appeals, they're right, for differing reasons, that say that you cannot get punitive damages in dram shop acts for the alcohol over service, right? So in this situation, despite Abuelos having a 3-drink rule and despite the TABC chart and the fact they don't have their people certified, they serve this guy 12 to 13 drinks. He leaves at the time of the crash. He's 3 times the legal limit, and he hits these 3 girls who are coming home from work 9 days before Christmas. Causes all 3 of them to have a head injury. One of them's got a profound brain injury for the rest of her life. And the other girl, her parents, while they were going back and forth to Lubbock, one of them was having brain surgery to get fragments out of her head. The other girl was on life support in Midland. This was their 3 daughters, 3 of their daughters. That's the way they spent Christmas 4 years ago. So this is important. These alcohol providers, whether it's in their actions of overservice or in independent actions, have a role to play in our communities. And in this situation, there's not much of a fight that they broke the law in overserving them. So, but we can't get punitive damages for that under these 2 courts of appeals opinion. And I'm not going to tell you that there's law otherwise. There's not. Supreme Court hasn't ruled on it, but they're not. But what we can get are punitive damages for negligent undertaking. And in this situation, even though they broke the law and overserved these, it wasn't like they missed the mark by 1 or 2 or 3 or 4 or 5 drinks. They missed the mark by 10 drinks. But even that, had they just done what they undertake to do, what they say they do, which is, hey, do you have someone to drive you home? We'll call you an Uber, or worst case, we'll call the police. The guy was blackout drunk. And within 18 minutes later, this crash happens when he's going 102 miles an hour in a 40-mile-an-hour zone and rear-ends these girls. And I understand why this is such a big deal to Abuelos. They don't want to be punished for what they did that night. I get it. But the Supreme Court has said that argument that Abuelos just made, that was made in 2002. And they said, no, the Dram Shop Act doesn't eliminate every single thing a provider does with the exception of serving alcohol. Now, the only difference in that situation is it was an independent contractor, and Mr. Rios was not an independent contractor. So there's not a case to address this exact point for either side. But here's what I would humbly suggest practically that could be done to to help the situation. So, which is a little different than what the trial court faced in the Love case. The trial judge there was faced with, okay, I'm granting summary judgment on the safe harbor. There's not even much of a fight on it here. So what do I do on this other point? And the trial judge was left with, well, which way do I go? And the trial judge made a decision to follow the argument that Abuelo's counsel just made. The Supreme Court and the Court of Appeals disagreed with the trial court, but it was kind of no harm, no foul. The trial court goes this way or the trial court goes that way. Anyway, it gets decided. Here, we're going to have a trial on the alcohol over service claim, the dram shop claim. So that trial is going to happen. So what the court could do is granulate the decision. So we could say, was there an alcohol over service? And that's submitted that way. Then the next question would deal with negligent undertaking. Then we have the punitive damages based solely on the negligent undertaking, not the alcohol over service at the end of the jury charge. That way, look, if our interpretation of what the Texas Supreme Court is saying, and this extension applies, then okay, that's that. The Court of Appeals, the Supreme Court can affirm. If we're wrong, it's granulated, and the Texas Supreme Court or the Court of Appeals could just X out the negligent undertaking and the punitive damages. No harm, no foul. We don't have to come back and retry the whole case. Under Abuelo's position, they don't have a case to support what they're saying. They marginalize Love, but Love is very clear for the proposition that the Dram Shop Act doesn't bar all claims everywhere with regard to a provider of alcohol. It's very clear on that. So if the court were to grant their summary judgment, we would have to go try the alcohol over service case. Then we take the other issue up and say the Court of Appeals or the Supreme Court agrees with us. Now we've got to go back and retry this whole case again on the negligent undertaking and the punitive damages. Seems like to me the way to resolve this is to submit them all, and that way we've got everything decided, and the Supreme Court or the Court of Appeals can make the decision. So that's that. There were a few other, just kind of little things that were brought up. The first thing he said is that we brought a negligence cause of action. Aside from negligent undertaking, the court probably is aware, I assume Abuelo's is aware, their charge talks about this. The way the PJC submits a dram shop case is it's submitted as a negligence cause of action. So with a definition that describes what negligence is. So, I mean, I think that must just be an oversight by Abuelo's on how it actually gets submitted, or I don't know, but that's that. Punitive damages obviously stem off, they're not an independent cause of action. They stem off of the gross negligence of what Abuelo's did with regard to their negligent undertaking. They had conscious awareness of their own practice and procedure. They knew exactly what they were doing. In this situation, the manager took over the tab. He looked at it and he just went home. I mean, you can see these people are drunk. There was 185 drinks served to this group on this night. These people were drunk. There was a whole group of them she had to cut off. So there's clear, I think that's the other reason they want to fight it so hard, is they know if the jury hears this, they clearly were consciously aware of what they needed to do. And even though they just broke the Dram Shop Act, they still had an opportunity to save this family, and they didn't do it. The server didn't do it, the management didn't do it, and nobody didn't do it. And so we would humbly ask the court to deny their summary judgment motion, allow the court to see how this goes during trial, and submit it. Allow the jury to decide it, and we put it in a position where if the Court of Appeals or Supreme Court needs to look at it, they can. But thank you for taking your time this morning to visit with us about these motions.
Sure. Okay, Mr. Fleming, any response?
Briefly, Your Honor. First of all, I want to emphasize, first off, not what Mr. Bailey has presented in his argument, but what Mr. Bailey has not. And that is, again, I'm not sure I understand his argument there. Again, if you look at his petition, we are being sued for 4 things: negligence under respondeat superior, gross negligence and malice. That's what they pled. That's in their petition. I'm not sure what Mr. Bailey's talking about with respect, well, you submit a negligence as a PJC. That's not really relevant with respect to what it is that we're being sued for. I go back to the point that I made before. They sued us for these 4 causes of action. We move for summary judgment on these 4 causes of action. Even now, Mr. Bailey has not presented any argument on those 4 causes of action. He's talking about an action, a negligent undertaking, which I think is not in this case, or at least not properly pled. That's number 1. Number 2, Mr. Bailey, again, relies exclusively on this Love case, which again, I find a little bit mystifying. Because allow me to read you exactly what the Love court's holding was. And this is why I think Mr. Bailey is misstating what this case actually stands for. The Love case does not stand for the proposition that entities or individuals such as the Tenorios have a negligent undertaking action in every situation involving the dram shop. If that were the case, Your Honor, I can guarantee you there would be a case at some point in the last 20 years where someone has tried to do this. They haven't, because that's not what Love says. What Love actually states, and I quote, "The Dram Shop Act was clearly intended to preempt common law claims against commercial sellers of alcohol for claims that arise from the seller's provision of alcohol. However, we conclude that it does not bar all common law liability by any conduct by a seller toward its employee or independent contractor wherever alcohol is involved." That's the holding of the case. What Mr. Bailey would like the court to ignore and focus it is essentially 1/2 of that sentence. He would like the court very much to say, okay, we conclude that it does not bar all common law liability for any conduct by a seller, period. That's not the holding. The holding says towards its employee or independent contractor. And again, the issue that Mr. Bailey is raising here with respect to the manual, again, has no applicability here in any way, shape, or form, because the allegation in that case was that the employer or the entity that employed her as an independent contractor actually instructed its waitresses to take specific steps to increase the number of alcoholic drinks that customers bought for the dancers. And her consumption of alcohol was not wholly voluntary. There was both testimony to that point, and I believe one of the things that they relied upon was this manual, which discussed this specific issue. It is a little bit difficult for me to understand how that is in any way, shape, analogous to a situation where we have an alcohol service manual, 1 page of which talks about what happens if someone does become intoxicated on the premises. Finally, Your Honor, what they're talking about with respect to this idea that, well, let's just go ahead and kick the can down the road, we'll present our evidence and then see what happens. Your Honor, I will give Mr. Bailey credit for being a good and a competent and a smart lawyer. And I believe Mr. Bailey knows perfectly well that if a negligent undertaking question is presented to the jury, this is reversible error. Because everything that we do from this point forward, if any evidence is being allowed to present to the jury on that, it's going to be flipped by the Court of Appeals. And I suspect Mr. Bailey knows that. I suspect that Mr. Bailey what he's trying to do is have his cake and eat it too. What I think Mr. Bailey, and I think you heard this, what he really would like to do is to present all of the evidence in this case as though he were going to be asking for punitive damages. You heard exactly what he's going to argue in that regard. Go through, present all that evidence, present it as though it were an exemplary. He will ask the jury to punish Abuelos, which he's not allowed to do unless he has an exemplary damages claim. And then at the very end, maybe he'll throw up his hand and say, you know what, Judge, we'll be okay with the DTPA action. We'll just let that. We'll go ahead and voluntarily withdraw the action on the negligent undertaking. At that point, Your Honor, the damage has already been done. The reason that I think he wants to do this is, as you've just heard him say, he wants to argue to this jury that Abuelos should be punished. He knows he can't do that under the Dram Shop Act because the Dram Shop doesn't allow exemplary damages. This is Mr. Bailey's attempt to, I think, get around that. Now, the other thing that Mr. Bailey did not address is this idea that, well, we can point to one page of a policy manual and that supports negligent undertaking. Again, Your Honor, if you look at the cases that we cite on, I believe, pages 5 and 6 of our reply brief, and I'll pull those up in just a moment. Your Honor, again, this argument has been advanced and rejected by every single court that has ruled on it. Case of Intex, case of Cleveland Regional Medical Center, case of the State of Caitlin versus General Motors Company, case of Owens versus Comerica Bank, Jacobs Cathy v. Cockrell. Every single one of those cases, which are cited on pages 7 and 8 of our reply brief, discussed a situation where someone was trying to rely upon a company's internal guidelines and policies in order to create a fact issue to support a negligent undertaking claim. In every single one of those cases, Intex, Cleveland, State of Caitlin, Owens, Jake Cathy, every single one of those, the courts uniformly and consistently held that cannot, as a matter of law, support a negligent undertaking claim. And I have not heard anything from Mr. Bailey that would put this case in a different category that would distinguish anything from any of those cases. So any way you want to look at this, again, and I want to be clear on a couple of things, Your Honor. We're not arguing that this isn't going to go to trial. We're not arguing that the plaintiffs are not going to have their day in court. As Mr. Bailey said, this is a case that will go to the jury on the Dram Shop. We are not arguing and we are not taking that position. Mr. Bailey will be able to argue, I think, forcefully on behalf of his clients in a number of these respects. But he has to do so under the law, and he has to do so under the Dram Shop Act. He is inviting reversible error by asking the court to go outside of the Dram Shop Act. And I think, and again, you heard him. What he wants to do is argue to the jury that, well, let's just go, you need to punish them, and you need to punish them hard. Again, Your Honor, unfortunately, Texas law is absolutely clear on this. And I do want to clarify one thing, and I do want to state Mr. Bailey was correct in saying that El Chico was the first case that came out in 1987 from the Texas Supreme Court that for the first time imposed common law duties. Prior to El Chico, there were no common law duties for alcohol providers. The Texas Dram Shop Act was enacted specifically to address El Chico. So I just wanted to clarify that point, Your Honor. So finally, in conclusion, Your Honor, I don't really understand why we are having the arguments that we are today, because there seems to be so much of a risk involved for both the plaintiff's attorneys and the court in allowing a case and a claim like this to move forward when it is so clear that every single case and every single argument and every single statute definitively states that this is not appropriate within this context, particularly because, as Mr. Bailey said, they're going to have their day in court. They're going to be able to present their evidence. They're going to be able to argue their case. They just can't argue it for punitive damages. Thank you.
All right, let's move on. Motion to exclude opinion of Bradley Ewing.
Your Honor,
Yeah.
Your Honor,
Yes.
I'm at a mediation in Hart Preston's office, wanted to appear on the motion for summary judgment, add a couple of cents, but Mr. Bailey covered every point that I would. I'm going to stay on, but if I could be excused, and if they need me in connection with anything scheduling, Brad Miller can text me. I apologize, but I'm in this mediation.
Okay.
If that'd be okay with the court.
Yeah, that's fine. I'm sorry. If you want to add anything, you're welcome to do so.
No. The argument was made very well. The only point, you got two acts here that could have been done to prevent the tragedy that happened to Number one is not oversell as a provider, and number two is not let him leave. And the situation, once again, I don't mean to over argue, and with all due respect to counsel, what if you had a guy that comes walking into Abuelo's drunk or impaired on drugs, obvious, doesn't buy a drink, meets a group, eats a taco? That would violate their express policy and in letting that person leave. And that's kind of what I had to add, but I, with due respect, I'd like to be excused.
Okay, you are excused. Thank you.
Thank you.
All right, Mr. Fleming, would you like to proceed?
Yes, Your Honor, if I may, and I'd like to start with Dr. Eilers instead of Dr. Ewing. There's some overlapping issues, and I think it'd be easier if we handle Eilers first.
Okay, and he's the one that they're going to bring in, I guess, next week.
Yes, Your Honor.
Sure. Okay. All right, we can go on Dr. Eilers if you wish.
Thank you, Your Honor. So, Your Honor, we filed a fairly extensive motion to exclude on Dr. Eilers. Dr. Eilers is a physiatrist. He is licensed to practice in Illinois and I believe Florida. He is not a Texas doctor. We found a number of challenges to Dr. Eilers. The ones that we're going to be talking about here today concern two specific late disclosed opinions. What I'd like to start with, Your Honor, with Dr. Eilers, is I want to talk about the timing of some of these issues and some of the deadlines that we have been dealing with for at least 6 or 7 months in this case. Your Honor, you recall that the court entered an agreed amended scheduling order, which set forth a number of the deadlines. The deadline for the plaintiffs to disclose their experts was on August 7th. And the way that the order was written was very explicit, and it required the plaintiffs to provide expert reports for all retained experts. That was in the order. And we did, in fact, receive a report from Dr. Eilers on August 4th. In those designations, Dr. Eilers was designated as a retained testifying expert. Now, based on the opinions that Dr. Eilers had in his August 4th report, we went out and interviewed several different doctors in several different fields and made the decisions as to which areas we would need to have rebuttal witnesses to testify upon to address the issues in his report. And we designated our experts and put forward our reports on September 8th. Dr. Eilers was deposed on September 17th. During his deposition, Dr. Eilers came up with not just a new theory and opinion, he came up with a theory that is not only contradictory to what was in his report, it is in fact mutually exclusive from what we had in his report. And we'll talk about that in just a moment. So we deposed Dr. Eilers on September 17th. Discovery in this case closed on October 7th. And I want to highlight that because, as the court may recall, Your Honor, we had been before the court on 2 separate occasions asking the court's permission to reopen discovery on a couple of different bases, mainly to inquire and ask further questions and conduct additional discovery on Julie Tenorio's current condition. And as you recall, Your Honor, Mr. Bailey, who was at that hearing, vociferously opposed our request to reopen discovery, not once but twice. Mr. Bailey stated very clearly on the record repeatedly that discovery in this case is closed, and he would only agree to allow us to conduct additional discovery upon his own agreement. And there were a number of areas that he did not agree for us to go into, particularly with respect to additional information regarding Julie's current condition. The court accepted Mr. Bailey's arguments twice and prevented us from conducting additional discovery that we had sought. 2 weeks after the close of discovery, we get a letter from Mr. Bailey in which we were told for the first time that Dr. Eilers was going to be having new records that he would be submitting to us shortly, and he was going to see Julie and reevaluate her. And again, to be clear, Your Honor, Dr. Eilers saw Julie Tenorio once back in July, albeit via Zoom. He came up with an evaluation, that was part of his report, and he came up with a life care plan. So essentially he is going to be reevaluating the plaintiff in anticipation of trial. Now, our deadline under the scheduling order to file Daubert challenges was November 3rd, and we did so. So we filed our motion to exclude Dr. Eilers. On the day that we filed this motion, the one that we're arguing about right now, we did not have any additional records from Dr. Eilers, none. We didn't receive those records until several days after we filed this motion. So the first time that we saw any of these records that were alluded to back in October was after we filed the motion to exclude his testimony. So I think that's kind of a problem right off the bat. So what I'd like to talk about, there are two different kind of specific categories here. What I'd like to talk about first is the opinion that Dr. Eilers came up with in his deposition. And at the outset, Your Honor, I have to admit, I'm not sure why we're arguing about this, because there's a timeliness issue, and that's what we're focused on today. But there's also a reliability issue in which Dr. Eilers admitted that he could not state that this opinion that we're going to talk about he can't verify that this will happen to a reasonable degree of medical probability. Notwithstanding that fact, plaintiff's counsel has refused to agree not to put this evidence forward. So we're having this argument, but I don't really understand why, since even Dr. Eilers himself seems to acknowledge that it's not a proper basis in an opinion. But be that as it may, in his deposition, let me back up. In his written report that we received on August 4th, Dr. Eilers stated that Julie Tenorio did not need full-time medical care or anything like that. What he stated in his report is that Julie Tenorio was going to need the services of an untrained caregiver 24 hours a day to essentially watch over her. That was his opinion in his report. Nothing in his report about anything involving any kind of medical intervention or anything else like that. Dr. Eilers priced this. He went out, did some investigation, and he said that, well, if you go out and you talk to the caregivers in the Midland area, you come up with an estimate of about $212,000 per year. So we go into Dr. Eilers' deposition with that opinion. The opinion being that to a reasonable degree of medical certainty on Dr. Eilers' part, Julie Tenorio will need an untrained caregiver 24 hours a day for the rest of her life, and this will cost $212,000. Now, in his report, now let me talk a little bit about the context about how this issue came up in his deposition. In his opinion, the written report, I should say, Dr. Eilers gave kind of a laundry list of all the different things that he believed these caregivers were going to need to do. In other words, what he was saying is, okay, here's my opinion, and here's why Julie Tenorio needs this caregiving 24 hours a day. So it's an important part of his opinion. During his deposition, we were asking him about some of these specific laundry list items about, okay, well, the caregiver was going to do this, going to help laundry, they're going to do this, they're going to help her with garbage, things like that. One of the items that Dr. Eilers identified in his written report that the caregiver was going to need to help Julie Tenorio to do was to help her manage her PTSD symptoms and provide her with other means of psychological support. So the question that we raised to Dr. Eilers is, well, hold on, how is that appropriate for an untrained caregiver to give that type of help and advice to Julie Tenorio? Dr. Eilers, in his deposition, said, oh, you know what? That's an excellent point. You're right. I've now changed my mind. I now believe that, contrary to what I said a month ago, Julie Tenorio may actually need the services of a licensed nurse practitioner to stand over her 8 hours a day, every day for the rest of her life. And I believe that this will increase the cost by about $100,000 per year. Dr. Eilers confirmed that that opinion appears nowhere in his written report. Dr. Eilers, and again, this is why I'm a little bit confused as to why we're even having this argument, Your Honor. And again, if necessary, we can talk about this in more detail on December 18th. But Dr. Eilers explicitly acknowledged in his deposition that he could not say within a degree of medical probability that this is something that she would actually need. So notwithstanding that, we're still having to have this argument because you saw from the plaintiff's response, they're still arguing they get to bring this in. So again, I'm a little confused as to why we're even having this argument, given that's the issue. The second issue that we need to discuss with respect to timeliness is very concerning, and it relates to these subsequent, quote, treatment of Julie Tenorio. And the reason that I want to highlight this issue of treatment is that I want to make it very, very clear on the record that Dr. Eilers is not now, nor can he be, Julie Tenorio's treating physician. And there are a number of reasons for this. First, Your Honor, and I think most importantly, Dr. Eilers wasn't disclosed as a treating physician. He was disclosed explicitly as a retained expert on August 4th. More fundamentally, Your Honor, the plaintiff's attorneys have treated Dr. Eilers as a retained expert by virtue of the fact that he was forced to provide a written report, which treating physicians obviously are not required to do. Not only that, but they have represented Dr. Eilers in terms of getting him forward for his deposition. We didn't have to go out. We didn't have to get a subpoena. So Dr. Eilers is clearly under the control of the plaintiff's attorneys here because he is their retained expert. Second point I want to emphasize, Your Honor, is as a matter of law, someone who is a retained expert can't then change their mind and then become a treating physician. And we talk about this issue explicitly in our motion on pages 12 and 13. There are no Texas cases on this point that we were able to identify, but there are several federal, Lowry and Tolliver in particular. And those cases are directly on point. What Lowry and Tolliver state is that when you have a situation exactly like the one we have here, where you have someone who has been a retained expert, who meets with the plaintiff once, and then is asked to essentially reevaluate the plaintiff prior to trial, that individual remains a retained expert and remains subject to the rules and procedures involving retained experts. That's exactly the issue that was present in Lowry and Tolliver, which we discussed. The final point that I want to raise with respect to Dr. Eilers not being a treating physician is that Dr. Eilers couldn't be a treating physician for Julie Tenorio because Dr. Eilers isn't licensed to practice in Texas, nor has he ever been. And Dr. Eilers acknowledged that repeatedly in his deposition. He acknowledged not only that he was not licensed to practice in Texas, he acknowledged that he could not treat Julie Tenorio in Texas. Now, I think what the plaintiff's attorneys are trying to do here is maybe try to fix some of this, because I think what happened is I think they put Julie Tenorio in a car and drove her up to Chicago and had Dr. Eilers actually meet with her in Chicago. Candidly, I don't think that that really addresses the issue here, because even if he met her once up in Chicago, he's giving her treatment recommendations and the treatment is going to be followed in Texas. So I think that's still a pretty serious problem. So the reason that I'm emphasizing this, Your Honor, is that I think if I read the plaintiff's response correctly, the way that they're trying to get around this and saying, oh, well, yeah, okay, maybe he was a treating physician, maybe he was retained, but now he's a treating physician. That's not correct. It's not correct factually, and it's not correct legally. He is and remains a retained expert. Because he remains a retained expert, he had obligations to provide us with all of the bases of his opinions on August 4th. And not only did he not do so here with these subsequent opinions, we didn't even have those at the time we filed this motion. Again, we're supposed to be filing a motion to exclude on all of the information we have. We don't even get the records until after we filed this motion. So, and I think what is happening here, Your Honor, is if you look at our motion to exclude Dr. Eilers, and we'll go into this in a lot more detail in December 18th. Dr. Eilers got himself into a world of trouble on a number of issues, not the least of which is this issue involving the treatment of Julie Tenorio and the fact that he apparently has been giving recommendations to her at a time that at least we would argue would not be appropriate and does constitute practice of medicine in Texas, which is not appropriate. Again, there's no secret about this. This was a very serious issue all the way through his deposition. I think what the plaintiff's attorneys are trying to do here is proactively try to fix this. And the way they're trying to do it is they're trying to turn him into a treating physician and trying to fix him by sending her up to Illinois. Again, I don't think that really addresses the issues. Now, when we did get these records after we filed the motion, I will tell the court, these aren't medical records. It's another expert report. It looks identical from a formatting perspective to the reports that we received on August 4th. There are entirely new opinions, entirely new analyses, entirely new methodologies, entirely new conclusions in this new report that we received that we didn't even have access to by the time that we were forced to file our motion to challenge him. So as a result, we're at a significant disadvantage because there are a number of those opinions in that report that I think are very problematic. And had we known about them, we absolutely would have challenged them on reliability and qualifications grounds. The deadline for us to do so has now passed. So I am very concerned about that. In particular, Your Honor, there are, and again, I won't go through all of them, but suffice it to say, I want to make it very clear, this is not a situation where he is just looking at Julie Tenorio and supplementing the report, as I think the plaintiff's response seems to indicate. There are entirely new opinions that have not only never been put forward by Dr. Eilers, they've never been put forward by any doctor anywhere in this case since 2016. In particular, Your Honor, there are some issues. Dr. Eilers apparently performed a fairly significant physical examination. He now has opinions that were not previously in his opinions, or indeed anywhere else in this case from any other doctor, that Julie Tenorio, as of today, is suffering from balance issues. And again, I just want to emphasize, Your Honor, the last time that Julie Tenorio saw an actual treating physician was in 2018. And those records don't indicate anything like that. And so now we've got a situation where Dr. Eilers, based upon his one evaluation of her, is now saying, well, she's got some balance issues that are related to the accident. That's not been in this case at all. Your Honor, you also may recall this issue involving Julie Tenorio's vision. This was an area in which we explicitly have asked the court twice to allow us to reopen discovery on a couple of different bases. And we have been prevented from taking any additional discovery on this topic. And Mr. Bailey has made it his position that we will not be allowed to do so because he won't agree to. Mr. Bailey is apparently of the position that that prohibition only extends to us and not to Dr. Eilers, because Dr. Eilers has performed a full eye examination of Julie Tenorio, which has, to my knowledge, never been done in this case before. Again, to emphasize the points that we made in some of our previous hearings, Your Honor, there's never been any question in this case that the accident and the brain injury has had an effect on Julie Tenorio's vision. That has been clear. The issue, however, is that there are references to a left field cut or impacts in terms of vision. There has never been a full ophthalmological examination from any licensed person that I'm aware of prior to this time. And in fact, even the records that we talked about that were involving, I think, Dr. Skaprinsky, those records, which occurred back in July, were not really a full examination. That was essentially an eye exam, and there was a diagnostic code on that saying that she has a hominis hemiopsia. There's no indication as to what the effect of that would be. There's no indication as to what was done. And in fact, we asked Dr. Eilers about that document specifically, and as we set forth in our motion, Dr. Eilers had absolutely no idea. He said, well, you're going to have to talk to her about that. I don't know what this means. So Dr. Eilers took it upon himself to perform this examination, this eye examination of Julie Tenorio, that, to my knowledge, has never been performed by any medical professional since 2016. And he's come up with some opinions that no medical professional has had since 2016. In particular, Dr. Eilers is now stating that her field of vision issues are not just in her left field of vision, they're now in her right field of vision. There is no indication from any record anywhere in this case that that was the case. There's always been a focus on the left field of vision. There's never been any indication that I'm aware of that this impacted both fields of vision. The only reference to something like this was a very early reference in 2016 to what's known as bilateral hominis hemiopsia. What that means from a medical perspective, as Dr. Eilers testified, is that it would mean that she is fully blind. And Dr. Eilers testified in his opinion that that could not be right because she was never blind. So there are no records anywhere in this case that would support what this issue is that he now has entirely no opinions on. And again, we have asked on 2 separate occasions to conduct additional discovery on this exact issue. We've been prevented from doing so. The plaintiffs apparently have continued to go down this path and continue to conduct discovery on this exact point. The final point that I want to raise, Your Honor, is in response to an argument that the plaintiffs' attorneys have made in their response. And if I understand the response, essentially what they're saying is, you know what, this whole thing can be fixed. We'll just put him forward for another deposition, no harm, no foul. Your Honor, nothing could be further from the truth. There is massive prejudice here, and it's not going to be cured by going out and taking his deposition next week. First of all, Your Honor, it is very, I think, we only have a month before trial. I think it is going to be very difficult, if not impossible, to find an actual time to set aside to focus on this, to actually do a full deposition. But let's assume for the sake of argument that we can find one. We're going to be doing it 30 days before trial. Your Honor, we've already locked in our trial strategy. Your Honor, as you've seen from the filings, we have submitted our motions in limine, our trial exhibits, our witness list, our depot designations, our motions to exclude. We are locked in to everything on that. And in fact, the only thing we have to do tomorrow, we've got to file our objections to their depot designations tomorrow. And then we're going to have our pretrial hearing on all these issues on December 18th. So the idea that we would have to go out and redepose plaintiffs, not just primary expert, but their exclusive expert on Julie Tenorio's damages. Again, he is their absolutely star witness on this topic. And what he would say is going to have a dramatic effect on how we present our trial. So we're already locked in on that. The second thing that I am concerned about, Your Honor, just with if we go out and take his deposition, if Dr. Eilers is allowed to testify on these new areas, what it means is we're going to have to go back and we're going to have to redesignate our experts. And it's not simply a question of providing supplemental reports from the experts that we have already identified. Some of these topics that Dr. Eilers is talking about, particularly with respect to the eye issues and the need of a licensed nurse practitioner and things like that, those are issues that may require a different field of speciality that we don't have in this case so far. So that means we're not only talking about supplementing the experts that we have retained, we're talking about going out and potentially retaining entirely new fields of experts to respond to these new opinions that were not in the original report. And then the final thing, Your Honor, is that as you've seen, as we're demonstrating today, we had a deadline of November 3rd to submit our motions to exclude. We did so, and that's what we're arguing about today, and we'll continue to argue about December 18th. If Dr. Eilers is allowed to provide additional testimony, particularly if he's talking about this eye exam, again, we have challenged his qualifications to have any opinions regarding the eye issues. And because he is a physiatrist, he's not an ophthalmologist, not a neuro-ophthalmologist, he's not a neuro-optometrist. We believe that is outside his field of expertise. So what we'd be having to do is we'd have to find a date for his deposition within 30 days before trial. We'd have to somehow redesignate all of our experts and potentially put them forward for deposition, get new expert reports for them. We would have to go through and file a new motion to exclude on the substantive grounds, depending on what he has to say in this new deposition, all within 30 days before trial. So for the plaintiffs to come in and say in their response, well, no harm, no foul, a deposition can cure all of this, I think is just in no way, shape, or form accurate. So that's pretty much the issues with Dr. Eilers with respect to the timeliness issues, Your Honor. As I said, there are a number of other issues that we will have to address with him concerning his qualifications, concerning his reliability, and concerning his methodology that we will address on December 18th. Now, the one issue that I am a little bit concerned about is, again, my understanding from Mr. Bailey is that he intends to bring Dr. Eilers live, or at least through Zoom, on December 18th. If Dr. Eilers wants to talk about, some of the issues that we've raised, I mean, that's fine. My concern, however, is I don't want Mr. Bailey and Dr. Eilers to start getting into some of these other issues because we intentionally bifurcated those. So again, to the extent that he's going to be talking about some of these new issues and new opinions and new qualifications, I don't think that's appropriate at all because, again, for the same reasons that we talked about, we did not have access to any of his opinions that he relating to the subsequent treatment of Julie at the time that we filed the motion to exclude. So to the extent that Mr. Bailey would try to present any of that evidence through live testimony, either through deposition or through Dr. Eilers as a witness, I think is inappropriate. Thank you, Your Honor.
Okay. Mr. Bailey?
Thank you, Your Honor. So I think maybe I'll address the second point. I think he really has two points that Abuelos is trying to make here. Number one, they're saying that Dr. Eilers, as a matter of law, cannot be a treating physician, and that's number one. And number two, I think, goes to some things that happened in cross-examination in his deposition. I think that's really all we're talking about. So on the treating physician idea, I think it was suggested that perhaps we tried to fix some big problem or whatever. When we designated Dr. Eilers, I believe back in August, we specifically said he's a retained testifying expert, but that as soon as the COVID restrictions lift in Illinois, that he will become a treating physician. So as the court probably remembers, this COVID has come in waves, right? And so in different states, it's been in different points. So at the time we designated in that middle part of the summer, Illinois was under some very significant lockdowns as far as Julie being able to go up there, so she couldn't. So as a practical matter, he met with her on Zoom, and we issued a report. And then we said very clearly, tried to give them a heads up, no trickery or anything. Our intent was for Dr. Eilers, who's one of the best physiatrists in the country, to treat Julie Tenorio to help her. And so, but that couldn't happen because of the pandemic. But we put it out there that he would. So then they got to take his deposition, fully disclosed everything. Took a very, I think, was it 10 hours maybe that Abuelos deposed him? It's the longest deposition I've ever been in my career. They deposed him over and over and over and over. And then once there was a little window in Illinois where the COVID cases went down before we had this big back uptick. And so Julie was able to go up there and treat with Dr. Eilers. Now, there are no new, as soon as she treated, we sent a letter, said, hey, Dr. Eilers is treating her, just like we talked about that he would. We'll get you the records as soon as we could. We requested them. And we said, if you want to take a deposition of a Dr. Eilers to learn about, what he found in his examination, we'll be more than happy to work with you. Abuelos basically said, no, we don't want to do that. We don't want to take his deposition. And I think probably so that they could kind of build some prejudice for themselves, because they said, no, we don't want to take his deposition. We want the court to rule on this. Okay. So that's essentially where we are. Now, Dr. Eilers, there's not any major wholesale changes it wasn't like Julie was all of a sudden he's diagnosed all these injuries that she never had before. As far as balance issues, she's had these since the very beginning medical record. This girl had a profound brain injury. She had a hole in her head with fragments. Initially, she couldn't even walk. So to say that there's nothing in the records that says she has balance issues, I just don't even understand that, Your Honor. She's had balance issues throughout the whole case. She talked about them in her deposition. All these witnesses have talked about her balance issues. She falls over. That was one of the new issues they said that would require all new experts and all this kind of stuff. Dr. Eilers, in doing his examination of her, he's not an optometrist. He's not a neuro-ophthalmologist. He didn't do some advanced eye evaluation. He did a normal eye evaluation that someone with his field would do. And he reported that. And she has problems in both eyes. From the very beginning, the doctors diagnosed her with bilateral homonymous hemianopsia. Now, there's two ways you can look at that. Bilateral, if it's half blind in both eyes, it means she's just completely blind. Well, everybody knew from the beginning she wasn't completely blind. And so what they were identifying is problems in both eyes. And that was from the very beginning. So Julie's primary problem, it seems, has been more with the left, but she's also had problems with the right. So this just isn't some new huge thing that all of a sudden we'd have to have all these new experts. As a matter of fact, I believe they've got 5 damage experts. They've never supplemented any opinion. Despite the 25 depositions we've taken, nobody's ever supplemented any. So Dr. Eilers, we did exactly what we told them we would do in the designation. We were limited by COVID. He's now begun treatment with her. As soon as we got the records, we provided them to him. We tried to say, hey, if you want to depose him on these issues, we'll work with you. And so, there's just nothing in the law that says we did anything wrong. I think I just heard Counsel for Abuelos say that as a matter of law, he can't be changed from an expert to a treating physician. There's no case in Texas that says that I'm aware of. Maybe Counsel for Abuelos misspoke. I don't know, but I'm not aware of a case that says you can't be an expert and then now become a treating physician. I'm just not aware of that. What we did do, though, I think some of the federal opinions, not the state opinions, but what we did is we've made sure that, number one, there was reports, there was depositions that they got to take. Dr. Eilers created significant, records that detailed exactly what he did in this visit so they could see it. And then we offered for a deposition if that's not enough for you to fully understand. And as far as them saying they didn't have the opportunity to make an expert challenge, well, as the court knows, the critical thing with the expert challenge is not their motion, it's the court's gatekeeper function, right? So the court, we've got a hearing next week. We'll have Dr. Eilers via Zoom. We'll ask questions. I'm assuming counsel for Abuelos will ask questions. The court can ask questions to see if he's qualified and follows a methodology as a physical medicine and rehabilitation doctor. And it was brought up in Abuelo's argument that there was additional discovery outside the discovery period they wanted to do. And one of them, you'll remember, Your Honor, is Dr. Walcott was Julie's treating physical medicine and rehabilitation doctor that they said we needed to hear from Dr. Walcott. Well, we took Dr. Walcott's deposition. And with regard to attendant care that Dr. Eilers says Julie needs, guess what? Dr. Walcott 100% agrees with that. So this treating physician that was so important that we needed to depose, they are now filing a Daubert challenge to him too. So not only are they trying to strike Dr. Eilers next week, but the treating physician of Julie, who Abuelos thought was so important that we had to do outside the discovery period, now they're moving to strike him because they don't like his opinion. And, Dr. Walcott's the treating physician that said that essentially he agrees with what Dr. Eilers is recommending as far as attendant care. And so we're going to have a hearing next week also on striking her treating physician that he doesn't know enough to be able to testify. So
Okay. That's all for next week, and those issues are, and I do want to keep it to qualifications and why they should be struck, not to subsequent opinions that have occurred after the deadline, or what's in reports that weren't timely filed.
Okay.
All right. Okay. Anything else on Eilers?
I think that's it. There's one sub issue that I really don't think is a timeliness issue at all. It's really a cross-examination issue. So but it's the first issue that was raised. So really the first issue that he talked about was this disclosure of a nurse practitioner or some type of a nurse, a healthcare professional being there with Julie 8 hours of the 24. So what Dr. Eilers says, based on reasonable medical probability, he believes is reasonable and conservative is to have an untrained person with her 24 hours a day, 7 days a week. That's also what Dr. Walcott, her treating doctor, believes that she needs. Now, we hired a neuropsychologist that they hired one too that relied on her data and pretty much agrees with her. I don't know about on the point I'm about to say, but on the data agrees with her. And she says that Julie needs care 8 hours a day from a social worker, someone at least that level to help her deal with all these things. So how it got brought up about the medical professional is counsel for Abuelos said, wait a second, you're saying Julie still has all these problems. This just untrained person may not be good enough. And Dr. Eilers said, you very well may be right. Depending on how she progresses and those types of things, you may be right. So that just really kind of comes up in a cross-examination point and something for the jury to evaluate. Dr. Eilers' opinions are disclosed that he believes, consistent with Dr. Walcott, that she needs an attendant 24 hours a day, 7 days a week. Our neuropsychologist disagrees. And there's an argument, a criticism that could be made that she needs more than that. So that's not an undisclosed opinion. It was discussed in deposition via cross-examination.
And this was timely, this point was timely disclosed. It's not in a report that was filed here recently.
It's not in any report. It was fully disclosed and examined in the deposition.
Okay. Yeah. All right. All right. We'll need to talk about that one more next week. All right. You want to move on then to Dr. Ewing?
Yes, Your Honor. Your Honor, I may respond to just one point that Mr. Bailey made on that.
Sure.
First of all, Your Honor, I don't want to get into an argument on some of these issues involving what Dr. Eilers' new report states and what it doesn't state. That's not before the court because it couldn't have been before the court because we didn't have the records at the time that we filed this motion. So I'm a little bit concerned by, again, if we need to have a different hearing and a different issue on that, we can, but we didn't have those records at the time. That's number one. Number two, Mr. Bailey stated that we are challenging Dr. Wolcott, but again, I want to make it clear why we're doing so. We're not challenging Dr. Wolcott as a treating physician because Dr. Wolcott is not a treating physician. He hasn't been a treating physician since 2018. What we are challenging is a very narrow portion of his testimony, which essentially is hearsay because he hasn't seen Julie Tenorio, heard from Julie Tenorio, or seen any medical records of Julie Tenorio in 2 years. What he did do is he had a conversation with Mr. Bailey for 30 minutes beforehand. That's the only basis of our motion for that.
Okay, I've read that motion and we'll take that one up next week.
Thank you, Your Honor. The final point that I want to make on this is that to the extent that they are saying that, well, there was no harm, no foul, because Dr. Eilers could have, because of COVID and all this, I'll remind Mr. Bailey and the court, this case has been on file for 3.5 years. The COVID restrictions didn't take place until March. To the extent that they felt that this is something that they needed to do or have previous treatment or have someone to actually look at her, they had 3 years to do so. And the fact that they are doing so for the first time after the close of discovery, and we're not even getting records from it until after our deadline to file a challenge on Dalbert grounds, is, I think, a little disingenuous.
Okay,
So,
I'm gonna take that fact into account when I rule.
thank
I'm
you.
not gonna rule today.
Thank you, Your Honor.
Okay.
Your Honor, are you ready to proceed with Dr. Ewing?
Yes.
Thank you, Your Honor. Dr. Your Honor, the only issue that we have with Dr. Ewing is, again, one of timeliness. And there are some similarities with what we're talking about with Dr. Ewing, with what we just talked about with Dr. Eilers, although I think not perhaps to the same extent. And we do not, we're not going to be hearing from Dr. Ewing next week. We're not challenging anything on Dr. Ewing's qualifications or reliability. We're not saying that Dr. Ewing can't testify. What we're saying is Dr. Ewing should be limited to his testimony that reflects the report that we received from him on August 4th. Again, going back to the timing issues, Your Honor. Deadline to designate for the plaintiffs and their reports, August 7th. We received Dr. Ewing's report on August 4th. Dr. Ewing, in that report, only had one economic analysis. Well, there's two, but we're only challenging one. He had an analysis regarding some present value issues for Dr. Eilers' life care plan. We're not challenging those. And we're not challenging anything in the August 4th report. The analysis that Dr. Ewing did on August 4th with respect to Julie Tenorio's future lost wages is that it was based on the assumption that Julie would be able to continue to work full-time as a store clerk, but she could not be a store manager. And he came up with a specific number that he believes represents the difference between those two over the course of her work-life expectancy. Based on that report, once again, we designated our experts. We chose experts to rely upon this, and we relied upon Dr. Ewing's report for both vocational and economic means. On September 15th, about 2 weeks after we designated our experts, in which some of our experts were critical of Dr. Ewing, Dr. Ewing issues a brand new, quote, supplemental report with two completely different scenarios. The first of these scenarios was a full loss based on what Julie Tenorio would have made if she were a supervisor but could not work another day in her life. The second scenario is a loss that he came up with based on if she were not able to walk, but she was confined to her current wages. Again, these are new opinions that were not in his prior report. His prior report assumed that Julie Tenorio would be able to continue to work. just not as a manager. And in fact, as a legal, factual, and a practical matter, that is the case, because Julie Tenorio was and remains, as of today, still gainfully employed at her employer. So she's still working there full-time as of today. So there's no real evidence to suggest that she's not going to be able to work, because she is literally working today. The only explanation that we received, so we took Dr. Ewing's deposition after we received this report. We did so making it clear that we were not agreeing that this report was timely, and we were asking questions about it only under an objection. When we asked him why there was this delay, the only explanation that Dr. Ewing had was that, well, plaintiff's counsel asked me to do it, so I did it. That's it. The issues here, and I understand what Mr. Bailey's position is, well, you know, we could have supplemented, we didn't have to supplement, but we did so anyway. Your Honor, that cannot be right. Because if Mr. Bailey's position is correct and say, well, we can supplement a report anytime, any reason, and we didn't even have to do so here, then why do we even have deadlines for experts to provide reports? That is not correct. It's not in compliance with this court's order, and it's not in compliance with Texas Rules of Procedure. There is no reason that if they wanted to make this argument that Julie Tenorio can't work another day of her life, and therefore they're going to have an economic analysis supporting that. Again, they had 3 years to do it. I do not understand why they're doing so only after we designated our own experts, some of whom were critical of Dr. Ewing. And again, just like we talked about with Dr. Eilers, we based our decision to hire certain experts based upon Dr. Ewing's report. And that report didn't say anything about Julie not being able to work another day in her life. So, and the final thing, Your Honor, is that when we were provided this report, we only had about a week from the time that we got the report to the time that we had the deposition. We had no ability, and as you may recall, Your Honor, we were very, very busy in this case up to the end of discovery. We had literally no days available from the time that we got the report until the close of discovery to reschedule Dr. Eilers' deposition, because we had a deposition literally every single day up until the close of discovery. So we got the report before the deposition. There wasn't any chance for us to get any additional time on that. In any event, it wouldn't have made any difference, because again, the damage was already done because we've already relied upon that from our experts. Our experts are out there, our experts have put their reports, and we made.
Hold on. Y'all, okay. Go to chat. Gotta go.
Thank you, everyone. There is a fire where the judge is, so this hearing is concluded. Thank you.
Thank you.
Thank you.